Hello everyone, this is MADHURI Paradesi, Associate Professor, Department of Law, Padmavati University. Today we'll have another topic, that is legality of objects in contracts law. What is a void agreement? Section 2G clearly gives you an idea of an agreement which is not enforceable by law can be said as a void contract. And Section 11 gives you a picture, an agreement made by incompetent parties, that is minor of unsound mind, incapacity parties, for other reason is void. Any agreement with a bilateral mistake has to be essential is called Section 20. Section 10 clearly gives you picture on an agreement which have unlawful consideration or void. Void contracts, if you can say that a contract turns voidable when the parties find some detects fault in the agreement and then they choose either to cancel or to accept it. Voidable agreements are nothing but it's a formal contract between two parties that may be rendered unenforceable any number of legal reasons, which may also include failure by one or both the parties to disclose material factor. A mistake, misrepresentation or the fraud can come under this, and undue influence or the duress. One or more terms are called unconscionable, and the breach of contract also comes under this. One party's legal incapacity to enter into the contract also can be taken. For example, a minor can come in this category. A voidable agreement is initially considered legally and enforceable, but it cannot be rejected by one party if the contract is discovered to have defects. If a party with the power to reject the contracts chooses not to reject the contracts despite defects, or the contract remains valid and enforceable. Most often one of the particular parties is advisable affected by agreeing to the voidable contract in which the parties fails to recognize that misrepresentation or fraud made by the other party. Differences we can see and the definition, nature and validity, facts, responsible and enforceability. Void agreements and the voidable contracts can come under this category. Section 2.1 clearly gives you a picture of void agreement. A contract which ceases to be enforceable by law, when it becomes void, it ceases to be enforceable. A void contract is an agreement which is enforceable by law at the option of one or more parties thereto. A void contract is void binding under the particular parties when enter into, but subsequently its intimation it becomes unenforceable to the certain persons. A void contract is if at the particular option at the aggrieved party, it remains a valid contract until it has becomes a party entitled to do so. Facts responsible will comes under a valid contract may become void due to supervising impulsivity can be taken. And coercion, undue influence, error, fraud, misrepresentation are the main factors responsible for entering of a contract voidable. Enforceability we can talk about, it cannot be enforced by either parties. It may be enforceable or set aside at the option of an aggrieved parties. Illegal agreements we can say it comes under common law of contracts, and one that the court will not enforce because the purpose of an agreement is to achieve an illegal, and illegal must result the performance of a contract itself. A contract for murder and all we can exemplarize like that, and illegal of a contract depends upon the law of countries governing the contracts, the law, the place of performances. Different rules will apply depending upon the law for relevant countries. Unlawful considerations, it comes under section 23 of a particular Indian Contract Act. Consideration, it may comes under the object of a contract, and considerable lawful considerations specified forbidden by the law of such nature, then they would defeat the purpose of law or fraudulent, involve injury to any other parties, person or property. The court regard them as immoral or opposite to the public policies. Case laws we can say 2007 Sarigama versus Sudesh Jindal and Boward versus American Horse Force we can refer. And finally, I would like to say, for a contract it is to be considered as a valid contract. It is important to have a lawful object and the lawful consideration. If either of the two is found to be missing, the contract is to be found and invalid in the total. To maintain fairness in the society, it is important to follow the norms, and in the case of unlawful object or unlawful considerations which in turn affect the society, this purpose cannot be taken into the pursued level. Thank you.